Hello and welcome to this webinar entitled Implied Terms, Good Faith and Braganza Duties, Key Principles and Practical Steps with me, Keith Markham. As always, let's begin by having a look at the agenda for this session today. So we've got three main topics, as indeed the title would suggest. We're going to begin by talking about implied terms, and obviously we know that the terms can be implied into a contract in any number of ways. However, we're going to focus particularly on two ways in which that can happen during this session today. So I'm going to look at implication of terms in law, but then we're going to spend more time talking about implication of terms as a matter of fact. And with regard to a matter of fact, we're going to be looking at two very well-established tests, which are often referred to as the Marks and Spencer test, following a leading case involving Marks and Spencer that we'll be discussing briefly. And they are the famous tests of necessary for business efficacy, or so obvious it goes without saying. So we're going to look at those, and we'll also look at other considerations that are relevant when we talk about implied terms. Once we've done that, we're then going to move on to talk about issues around the topic of good faith. And there'll be three things we discussed here. We're going to talk about the meaning of good faith, look at the latest thinking as to precisely what that means in practice. We'll then look at express duties of good faith. If we find them in a contract, are they enforceable? How will the court determine their interpretation? And finally, we'll also look at implied duties of good faith, drawing on some of the previous discussion to do with implication in law, implication as a matter of fact. We will look at what the current approach is with regard to that issue. And once we've gone through all of that, finally, we will wrap the session up by talking about so-called Braganza duties. Many of you will probably be aware of the famous Braganza case from 2015, which we'll be talking about, a Supreme Court decision that suggests in some cases where a party has a discretionary power under a contract, then they should apply it in a certain way. And sometimes the Braganza duty may apply, sometimes it may not. We'll look at the key thinking on that, and we'll look at one of the most recent cases on that to see how the courts are applying that duty these days. So let's begin then by talking about the issue of implied terms. Now, as I've said, implied terms can appear in many different forms, and many of you will be aware that they can be applied by statute. Classic example being the Sale of Goods Act, which implies various conditions into business-to-business contracts, things like satisfactory quality and fitness of particular purpose, and the fact that obviously the person supplying the item must own that item. So, as you will also be aware, normally what we do in a business-to-business contract is, to the fullest extent permissible by law, we exclude those. So typically, unless we've been a little bit sloppy in our drafting, or indeed, sometimes we find that the court decides that there are no express terms or there are gaps in the express terms, we don't tend to see much in practice by way of terms implied by statute.